Today kicks off our first ever 3-part series on one of the hardest questions family courts face. What happens when one parent wants or needs to move away with the child?
Mom shouldn't be rewarded for this thief sneaking away in the night with the child.
Best interest of this child. 3 weeks, newborn, mom. That's all you need to know. This is Split Decisions, where veteran family law attorneys go head-to-head over the toughest custody disputes facing today's families. Every trial has 2 sides. Which one wins? You be the judge.
Over the next 3 episodes, we'll debate 3 very different move-away cases: a military transfer, a career opportunity across the country, and today, a mother gives birth, then disappears overnight with her newborn to move in with her parents hundreds of miles away, without telling the baby's father. Was she protecting herself and her child, or did she unlawfully cut a father out of the child's life before it even began? I'm Carlos Tavares, and I represent the father.
I'm Tim Miranda, representing the mother. And after the debate, we'll have a discussion and give you some insight into how we make these arguments and what we really think about these types of court-ordered measures. Let's make our case.
All right, good morning, Your Honor. Today we're here on Father's RFO, and I've read Mother's responsive pleadings and we'll address some of that as well. But the bottom line is quite simply the parties dated, got pregnant, broke off their relationship, and she then gave birth. Father has been participatory in the entire process. So while they stopped dating, he was still supportive of Mother, all of her appointments, went to all of them, the sonograms, was in the hospital every day, and for 2 weeks was a participating parent with this child. So child's born, he's there every day, he's bonding with the child, and then up and out of nowhere, Mother just leaves. And he gets a text saying, hey, I'm safe, I'm in, Stockton with my parents. So we're here today because Father wants that to be undone. He wants to continue being participatory in the child's life, as he always has been. And Mother is simply moving away because she now states she was having a hard time, says my client wasn't supportive. That's simply highly in dispute. Working 60 hours a week, that's not really true. He did work and has to maintain finances, but the reality is he was there participatory at every step of the way. And ironically, they had discussed ever since she became pregnant, even though they weren't together, that they would work together on parenting. And then with no communication whatsoever, she just takes the child out of town and lets him know, hey, I'm staying up here now. So there's a couple of problems with this. We want the court today, we want to order that the child be returned to San Diego, and I'll discuss my client's availability to receive that child in a moment. Clearly want the court to make some custody orders regarding Dad having equal time with Mom. Obviously, we seek the joint legal custody. There's a voluntary declaration of paternity, the VDOP, so paternity should not be an issue, and he'll clearly stipulate to that at the onset, and we'll fill out and execute the forms necessary to make that happen. And we want the court to make a parenting schedule that continues Father's active participation in the child's life. Now, Mom in her pleadings made a lot of accusations against Dad in his, working and inferring that he was somehow not available. She doesn't dispute that he was there all the time. She does sort of dispute maybe it was less than 90 minutes or whatever, but that's that's a dispute. Dad has gone through great lengths. He's created a nursery in his house. He's purchased cribs, bottles, diapers, everything. Mom was aware of all of this and encouraging at least. So he's done this. He's now he qualifies as a parent through his employment for 12 weeks of leave. And Dad's very clear in his moving papers. I do work more than a 40-hour week, but I have the ability not to, and I will amend my schedule because I have that sort of control over my employment to provide a more reasonable schedule that can accommodate a mutual parenting schedule with Mom. Mom shouldn't be rewarded for this thief sneaking away in the night with the child. making it all about her needs when it's really about what's best for the child. So I don't want to downplay mom's needs, but they shouldn't be the primary focus of this, ignoring what's best for the child. Now I understand mom is alleging that she has postpartum depression or postpartum anxiety. I think that's all the more reason not to let her run away and sequester herself behind closed doors hundreds of miles away. All the more reason for dad to be present on a frequent and continuing basis. And that way we can just deal with that in its own course. She wasn't very clear, if at all, that she was having a hard time other than the standard things that come with a pregnancy and a birth. You're going to be tired, you're going to be up late, you're going to be feeding. There's a certain amount of exhaustion that's built into that formula. And mother never communicated that her exhaustion was to the point at a higher level, because father he's already arranged for a nanny to kind of help, and he's already got someone lined up. And had he been aware of that, he could have taken active steps to address what she is now alleging is her basis for the move. So on that, we would ask the court to enter the paternity orders that dad is the parent. He signed the VDOP. He stipulates to that the parties should have joint legal custody, and that the child be returned to San Diego, and we can work out financials then. My client has a good job. He's never really been hit up in any way, shape, or form for financial issues. We've never even heard of them or understood any financial constraints. We're just left with mom, who in the night took the child and went hundreds of miles away and is now claiming to have postpartum. Thank you, Your Honor.
Thank you, Your Honor. If my client had left during the day, would that have made a difference? This came to the court on the back of an ex parte application. There's no emergency here. There's no facts for an emergency that were pleaded, no 3064 reason to do anything. And what would you do? Because there are no operative custody orders today. My client left to another part of this state with the child. She has a right to do that, and there's no order that prevented her from leaving. What we do agree with, my client would agree to stipulate to the paternity. There is a VDOP, so that's not in dispute. So one issue is resolved. What I heard was a lot of mother victim bashing. She's got postpartum anxiety. Who diagnosed her with that? Who diagnosed her with the anxiety? And so what? She's got a 3-week-old infant. So maybe she does have some residual from the childbirth. I don't know exactly what that would be, but we're going to bash her then and say this is her fault. She's got anxiety. She shouldn't sequester, so she has to come back. So father is supportive. I heard that a lot. Is that supportive? Let's insult her. Let's kick her when she's down. We know why, because she's declared already why she's left. Her family's up in Stockton. She's got a support base. And father was abusive. She believes he was abusive. That's why, as you heard, she said, we're safe. We're safe. We're away from you. And if she was abducting or absconding the child, why did she text him anyway? Why did she even communicate? Wouldn't she just leave and you'd never hear again? This court is not a punitive court. This is the family court. You want punitive measures, you're in the wrong building. The thief rewarded. There is no reward. The child is 3 weeks old, and where would the child go? The child would go 50-50 with father. How? Maybe if he moves up to Stockton, maybe that would be an opportunity when it's right. But he hasn't had 50-50 in the 3 weeks since birth, and he has been working, and that's great. And he needs to keep working because now he has a mouth to feed because we just stipulated paternity. So I don't understand why this would ever be an emergency or why the court would think it's best to extract the child and have the child come and be with father. How's he going to feed the kid? Where does the breast milk come from? Is he going to squeeze really hard? What are we going to do about that? The fact that father outfitted his house, the fact that father bought bottles, great. So if he goes to Stockton, then he's going to have those things that he can pack in the U-Haul, and he can be an appropriate father. But right now, today, the child, best interest of this child, 3 weeks, newborn, mom. That's all you need to know.
Your Honor, alleging abuse to cover up what mother did in swiping the child and heading to Stockton is a bit of a stretch when it's really just what she's doing to try and justify her bad behavior. We do have federal statutes prohibiting kidnapping, though that doesn't generally it's not generally the nexus of the case, though it really is the essence of what's happened. Mother's condition is what it is. How is dad going to be aware of it when he's not around? Mother's move was to exclude father from parenting without so much as a text or a communication. The only thing stopping her from returning to San Diego is potentially finances, and dad has already registered a willingness to provide additional nanny type support. He never even got that opportunity from her. So this, oh, he's abusive, how convenient to have surprise and not a single ounce of evidence to support that. So we'd ask that the court order mom and the child to be returned, work and meet at least in the ex parte before we set this for a lengthier hearing, meet and confer on the financial issues and whether or not mom's move was actually legitimate or really just to divest dad from parenting because she just didn't want him around for reasons unknown. And if it's really driven by the postpartum depression, all the more reason to get that worked out before we start moving kids in and out of counties. Thank you, Your Honor.
Now my client has depression, and now she's
postpartum depression.
Now
Don't
my
worry, it'll
client
be here
has
next week.
Now my client has depression, and she's a kidnapper. So she's here in court today, appearing virtually, of course. So how many kidnappers show up in court when they've kidnapped a child? Depressed? Maybe he should have spent more time working on the relationship. Maybe if this relationship and keeping his ex-girlfriend around was so important, he should have been a better mate. I don't know, and I really don't care because that's not the thrust of the issue. It's the child, child's with mother, child's safe. There is no basis today to order that child back to San Diego. Thank you, Your Honor. All right, now for our candid counsel, what do we really think?
Yeah, if father was able to relocate, she couldn't do this twice.
Carlos is doomed because I represent the mother and the child is 3 weeks old and there's no current custody order that technically the mother has violated. So what she did is legally not wrong. It could be morally wrong. And the family court, like I said, is not there to punish. So you can't just make her come back or strip the child away because you don't like what mom did, even if you don't like what mom did. So Carlos already has a significant disadvantage. I do think he raised really good points. And I really believe that if this father were to relocate up to Stockton, if that's feasible for him, then this would be a completely different scenario.
But the real issue is the court is really left with something, what can they do? Yes, it was not cool. Yes, it intentionally and selfishly divested a parent of parenting. Yes, you removed a parent from a child's life, and we all know children need both parents. So it's abhorrent for all of those reasons, and I don't think any judge likes these cases. None of us like the move-aways. They just are inherently distasteful. But at the end of the day, the court then says, well, what options do I have? Now, if mom's an heiress living in Stockton and she can easily afford to move right back, the court's going to be very happy with that. But generally, these all follow the same pattern. You have a woman who's just given birth, so she's not able to work. She does need the extra help, and it's very common to go to your parents for that help. You kind of move back in with mom or dad type thing. So it's a very common fact pattern. It's a very human fact pattern. So as much as we don't like it, it's so comfortable and normal to us that the thought of taking a little infant away 6 months, 8 months, 10 months, what are you going to do? Ship them down to spend 50% of the time with dad? We didn't even get into whether there's breastfeeding, and we all know the bonding of a child and a mother and all the oxytocin and all the things that occur are super developmentally important. And we can't just go ripping that out. So dad deserves justice and mom doesn't deserve the reward. But when you look at it from what the child needs, he needs a close connection with the mom to be maintained. And the court is left with what resources do the parties have to allow father to have more time with that child, keeping the stability for the child. So it's a little abhorrent.
I hate these cases. I've represented in my set of facts, it's always been a father, and the mother has left. And typically, as Carlos had noted, the mother will leave in the middle of the night. There's usually some type of a ruse, like I'm going to go take our child up to meet the grandparents or some of my extended family. I'm going to stay up there for a little bit. I need a little bit of a break. And then that turns into, at some point of communication, I'm not coming back. I'm not bringing the child back. So fundamentally, if you start with that, someone walks through your door and you have to tell them, if you know what you're doing, look, legally, there's not a whole lot I can do right now to help you. We can try to go ex parte, but that's very likely not going to be successful. We have to start somewhere, but you really need a strategy. And so I try to help people with a strategy, as I mentioned here, and if it would be feasible, then you'd want the father to relocate. If the mother's going to go there, he'll be there next week. He's packing the truck right now. What are you going to do about that? But yeah, I don't like these. The court doesn't like them. I watch them a lot from the audience when other people are arguing them, and invariably when you go in on an ex parte, you don't get any relief.
Yeah, that's it. And it's not just within the state. So we have a lot of cases where they'll go to another state, and then you're filing for a home state issue here in California because mom and child are now in Colorado. And it's just a real mess, and it's a little disheartening because it's very hard to objectively see this being done with a child-focused parenting model. So the law in our state is it's fairly old, it's fairly flushed out, but that presumptive right to move, we're stuck with that in the state of California. Many of us would like that to have gone the exact opposite way. A parent has a presumptive right to move, fine. But if you are moving, the kid stays in their environment so it doesn't disrupt the child and the bond with the other parent due to your unilateral decision. But all of the cases, Burgess, Lamache, Condon, we're just sort of stuck with that's the presumption. So we look at the presumption, so we can't really do anything about that. And then we look at how do we really go through all of the elements for the best interest of the kids. So it shifts it into a much longer game. So it's a tough case, and I don't think anyone likes them.
Carlos just touched on a point that's pretty pernicious. If somebody leaves the state, goes to, say, another state, unless your attorney in California is licensed in that other state, now you have to get somebody in that state, because what they do is they go to the new state, then they file something there, they retain counsel there, but then you're in California with the father, and this is where the child was born or had been living. So then, as Carlos mentioned, you have a jurisdictional issue. You typically have to associate with an attorney that's in that state. So we might have 4 attorneys fighting this battle. So oftentimes it can come down to who has more resources. But it just gets really messy, consumes a lot of time. The judges ultimately are going to have to speak about who's got jurisdiction. It's just a real waste, and it's a real shame. But it happens. If there were a custody order that were effective when the mother left, if the mother were violating the custody order, now we have an order that's being violated. So now the court inherently has to enforce its order. So what can be done about that? That's a whole nother episode. But the point is, if there were a custody order violated, boom, now Carlos's client has a lot of means to get that child back, because the court's already determined with that order what's in the child's best interest. And now the mother in this case is fleeing and doing something that is directly opposite to that. So yes, here the opportunism is, kid is typically just born, everyone is cooperating, so nobody thinks they need to go to court. Probably the right way to be thinking. And then guess what? Boom, I'm out of here. Now you're screwed.
Yeah. So, and I don't know that it's a much different position for dad to be in, but it's very fact sensitive. And generally, if someone we have a lot of cases where the one parent is, bottom line, a runner. They're just going to do what they want, and they're going to go what they go, and they're going to say what they say. So if a parent with an existing custody order after, say, a year, where you've gotten that first one and she just doesn't like it and she bolts, and then you're going to court going, hey, violation of the order, and you know what's coming back. You know there's going to be some allegation of domestic violence, some justification to cover the willful act. So they become very complicated. And we have cases, we've had them, lots of them, not lots, but it's a fairly common fact pattern when they go to another state, file something, you got to file something here, and then you have this sort of big open hearing between two judicial officers, and these have been going on for years. And what's interesting is sometimes we've had budget cut years, and the dispositive factor for where it was, for example, the California judge didn't want any more on the caseload and yielded jurisdiction to the other side. So not only are they kind of just convoluted with a lot of procedural things, but you also have just political, financial, economic things that can sometimes show and have influence. Or you have a child that has been in another jurisdiction and is now residing for the last 5 years in California, and you go to ask, say, the Arizona court to relinquish jurisdiction, and for reasons of a possessory mindset, they go, no, we're not letting go, and none of it makes sense. So you then are dealing with all these other extraneous factors, which just make it a lot more complicated. So it's a tough pot. You ask us if we like them or dread them or hate them. This is what we do every day. We'd prefer to have cases that are more just and make more sense and have people really putting their parenting of the children first. But this is what we do every day, and we sort of know what the rules are, so we don't like it, but it certainly isn't something that haunts any family law practitioner. Now it's your turn. Did the mother have the right to leave with the baby, or should the court order the child returned so both parents can begin on equal footing? And you can tell us who won today's arguments in the comments.
And don't miss parts 2 and 3 of this special series, where we'll tackle a military relocation and a parent offered the career opportunity of a lifetime across the country. We'll see you next time on Split Decisions. Subscribe for more real-world legal debates on the AM Sidebar.